Call this meeting of the Town of Clayton Board of Adjustment to order. Appreciate everyone being here tonight. It has been a little bit since we've met, but thank you all for being here. And we'll move on to our next item, which is item 1B, the roll call of the Board of Adjustment. Turn it over to staff.
Hello, sorry about that, Chair. Thank you.
No problem.
We'll go ahead and do a roll call. Marty Bizzle, Chair.
Here.
Rebecca Berry, I have her noted as the Vice Chair. She's absent, excused. Board Member Perricone, Jim Perricone.
Here.
Board Member Richie Wiggins has emailed me and is excused. Board Member Joseph Warta.
Here.
Board Member Rich Maida is absent. And Board Member Karen Spicer.
Here.
Thank you, Chair Bizzle. We do have a quorum for action that is going to be before the board this evening.
Thank you, Conrad. All right, item 2, adjustments of the agenda. Any adjustments to the agenda?
Board Member Bizzle, I know we had just reviewed the minutes for the March 19th meeting. I would ask that we postpone that vote this evening because I'd like to confirm that we have, I wanted to note that the minutes reflect co-chair Spicer, and my notes say that the co-chair or the vice chair was Ms. Berry. I just want to double check this.
What?
I am sorry about that. I am losing my mind. I apologize. So the minutes as reflected, they are the March 19th minutes, meeting minutes. We would be amending the minutes to reflect an update from co-chair to vice chair.
Okay. So we will actually be voting to approve the minutes of the March 19th
Correct.
minutes with those corrections that were just noted by staff.
Motion.
Have a motion to approve the minutes of the March 19th meeting by Jim Perricone.
Motion to approve with the amendment of co-chair to vice chair.
Okay, we have a motion to approve by Mr. Perricone. Do we have a second?
Second.
Have a motion and a second. Any discussion? All those in favor say aye.
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 Opposed? Motion carries. Moving us down to item 4, evidentiary hearings, case number 2025-44-SUP, held stop for Johnston Medical Center special use. And before we start that and before we hear from staff, I'd like to turn this over to our board attorney, Mr. Raspberry, to basically go through some ground rules since this is a special use permit and evidentiary hearing. Will be following the quasi-judicial rules, and just ask Raz if he would give us a little bit of a background and some ground rules. Once. There you go.
Good. Thank you, Mr. Chairman. My name is Francis Raspberry. For those I haven't had the pleasure of meeting, I go by Raz. I answer Raz, a nickname, and that's the informality is perfectly fine. I've been counsel with the Board of Adjustment for a couple of years. Marty's asked me to make a comment or two concerning the quasi-judicial hearing process. It's been a while, I think, since we've had a hearing. The courts in North Carolina in the last 25 years have really clamped down on decisions made by local government boards concerning the rights of individuals to develop property. Used to be they were considered to be public hearing-based decisions like zoning ordinances and budget enactments and that sort of thing. And the courts have told us that no, a quasi-judicial hearing is required whenever a public body is evaluating the right of an individual to use their property based upon a determination that is premised upon some legal criteria, whether the criteria have been met or not. And the courts have said that that is quasi-judicial or court-like in nature, and it is distinctly different in terms of a decision by a local government board than what falls within the other category of local government decision-making, which is legislative decisions. Hearings before the town council are legislative or rule-making in nature, and the legal requirements are not nearly as stringent as they are for quasi-judicial or QJ decisions. The process and the decision are subject to the constitutional due process of law requirements. I won't go down the list, but there are some fundamental rights and obligations that have to be observed. The right to take sworn testimony, have all evidence presented either through sworn testimony or through other means that passes the test for substantiality of evidence, right to counsel, right of appeal, a record has to be kept of the proceeding, right to be cross-examined or to cross-examine witnesses. And then finally, there is a requirement that the decision be codified in the form of formal written findings of fact and conclusions of law and the decision of the board. The order of presentation, first of all, let me say this, the strict rules of evidence that are applicable in a court don't apply to a Board of Adjustment hearing, but there are some rules, there are some requirements. The most notable relate to evidence which involves special expertise or qualifications, where an expert witness would be required in a court of law. If opinion evidence that requires special expertise or experience to be reliable is offered, it's appropriate to ask that the individual who's going to be testifying as to that evidence or using documents or pictorial exhibits and so forth be first qualified as an expert. Used to be it made a difference if there was no objection from an opposing party. The legislature has tightened up on that. And even if there is no objection, there is a requirement that special testimony that requires special expertise be offered only by a qualified expert witness. There are two categories of testimony where the statutes require expert testimony only, and that is traffic safety, evidence presented on the issue of traffic hazards, traffic safety, or evidence that relates to the effect of whatever is being proposed on the property, on property valuation. And then there's a catch-all that says, notwithstanding no objection, if there's any other evidence being offered that requires special expertise to be reliable, then the giver of that testimony has to be qualified as an expert. The order of presentation of evidence and statements in these cases, the staff makes its initial, first of all, the public hearing or the evidentiary hearing is declared to be open by the chair. Then the staff makes a report, a non-advocacy type of report explaining the context of the request for the special use permit. The applicant goes first, presents the proposal and offers evidence in support of approving the application for the SUP. Questions may then be asked by the board of any presenter of evidence by the applicant. Following that, the chair will call for any other speakers or any others who want to speak in opposition to the application. Questions, if someone does offer testimony at that point, the board can ask questions of each individual witness at the lectern. All witnesses must be sworn, that's one of those legal requirements as well for a due process of law to be respected in a QJ hearing. Following the presentation of all the evidence, if the applicant wants to make a closing statement of its contention, that would be fine. And then at the conclusion of all of the evidence, the hearing is declared to be closed. At that point, the board will deliberate on what it has heard and then render its decision to either grant or to deny or grant with conditions the application for the permit. Finally, there has to be a written order. I think there's a sample that's already been prepared by staff that's in your materials, but there needs to be an order signed by the chair that substantiates the decision of the board in the case. And I have one final annoying lawyer comment to make, and that is, I understand in this case, the applicant, and this is for the benefit of the applicant's representative, the applicant is not represented by an attorney. Am I correct on that? The State Bar of North Carolina has issued a formal ethics opinion that for an individual to appear in a representative capacity in a local government QJ proceeding, that is the practice of law. And potentially, that could be the unauthorized practice of law if a layperson presents a case for anyone other than the individual presenting his or her own case for property owned by the individual. In every case where you have a business applicant, the State Bar opinion applies that a lawyer is typically required. Clayton doesn't require lawyers to appear in its cases that are heard being brought by business entities. What we have, the workaround we have employed in the past is as the presenter or witness for the applicant goes to the podium and begins to speak, I'll ask if that presenter would acknowledge for the record that they're not here to serve as a representative of the applicant, that they are here as a fact witness only to answer questions and to give testimony concerning the factual matters that are in dispute in the case, but not to do what lawyers traditionally do, which is to introduce the case, make arguments, offer contentions, summarize evidence, make final arguments in support of the application or anything that lawyers, behaving like a lawyer, if you will, because you may not be representing a party in a QJ proceeding without running afoul of the State Bar rules. So with that caveat, I think that's all I need to say. I probably have said too much, but thanks for your patience.
Thank you, Raz. We appreciate that. It has been a minute since we had a case, so refreshing us as well as the applicant and the board is always appreciated. So thank you very much. I would, before we swear in the staff and those wishing to speak, I would like to disclose that my company is a consultant for UNC Johnson Health. We are not a part of this project and whatsoever, and we stand to gain no financial gain either for or against as far as the item before us tonight. I wanted to disclose that at this time.
And Mr. Chairman, I'll just add, Chairman and I have discussed this briefly. There are requirements, there are statutory provisions relating to conflicts of interest as potentially running afoul of the legal requirement that the applicant have its case heard before a fair and impartial tribunal. And there's a statutory standard and there's some case law. In my opinion that I expressed already was that clearly the fact that his company, the company by whom he is employed, has done work for the applicant's firm is no reason, it does not trigger the statutory provision where it would be prohibited for him to participate in this case. But that's our legal opinion on that point.
All right. Thank you very much. All right. At this time, I'd ask that anyone wishing to speak on this matter before us tonight be sworn in by our clerk.
Chair, will you open the hearing?
Yes. The hearing is now open.
Thank you. Everyone, please raise your right hand that's wishing to provide testimony. Do you solemnly affirm that the testimony you're about to give is true to the best of your knowledge and belief? Thank you. When you step up to offer your testimony, please sign the oath sheet.
All right. We'll now turn it over to staff, and our presenter tonight is Robert Tate, the senior planner with the planning department. Welcome, Robert.
Good evening, board and chair. Thank you. Robert Tate, senior planner with the planning department. Before you is the special use permit for the Helistop at Johnson Medical Center. This is project number 2025-44 SUP. Like I mentioned, this request is to facilitate the relocation and expansion of an existing helistop on the hospital's campus. The subject site is on a property that's approximately 34 acres in size and is located on the northern side of Veterans Parkway, just south of Amelia Church Road and north of Interstate 42, with the property address of 2138 Veterans Parkway. Here are a couple images of the posted notice that is required for this evidentiary hearing. So really quickly, I want to go into the background of and why you see this request tonight. So a little background history on the helistop that currently exists on the site. It was approved in a site plan from 2012 with expansion of the hospital. During that time, it was reviewed under the Unified Development Code. So in that code, the helistop use was associated with the hospital use as a supportive facility. So it was a permitted use tied to the hospital, which did not require a special use permit at the time. Kind of fast forward to today, under the current Unified Development Ordinance, the UDO, the helistop is a secondary use, but that requires a special use permit, which is why you see this request tonight. So today, the existing helistop is a legal non-conforming use, but it cannot be expanded for further use. So that's why you're seeing this request tonight, because the helistop is being moved and also expanding the use area. So going a little deeper into the proposed helistop, the existing is 40 by 40 feet, and the proposed helistop is going to 50 by 50 feet. So expanding that use and triggering the need for a special use permit. So compliance with the UDO would require a special use permit and require your action tonight. Going into the concept plan here on your screen just shows a brief visual of the proposed work to be done. So the red 40 by 40 pad that you can see here, let's see if this works. Okay, it's not, but it's fine. The 40 by 40 pad in red is showing the location of the existing helistop, and just a couple hundred, maybe 100 feet to the west is the proposed new location of the expanded helistop in the green. So we are looking at some conditions of approval. This is kind of your boilerplate standard conditions of approval that would be associated with a special use permit. So I won't go into the details with that, but the first just speaks to the concept plan that you just saw and its relation to these conditions. And then the remaining are some kind of administrative language. Really big important condition to this case to note is the seventh condition. The seventh condition was placed so that the applicant would provide an aluminum fence around the proposed helistop. This fence would reflect or be a similar fence that is currently around the existing helistop today. So they are going ahead and kind of guaranteeing that an aluminum fence that matches the existing one today will be placed where the proposed helistop will be. And then lastly, just a few considerations for you all before you hear from the applicant. This is an evidentiary hearing, so you may approve or deny this request. You may consider this in my staff report. And what you may do tonight is either add or remove conditions of approval. At your request, you can ask the applicant to remove those, or you can also have this item go back into the technical review committee for any additional considerations. And then the last thing is that what you'll hear from the applicant in a moment is the facts of finding. Those things are something that is going to be provided by the applicant only. So with that, if you don't have any questions for me, I will go ahead and pass it over to the applicant.
Any questions for staff? Thank you, Robert. All right, now we'll hear from the applicant.
Do I need to sign in, Okay. My name is Sam Bohannon. I'm with Ingram Civil Engineering for this project, and I'd like to thank the board for your time here tonight. Thank you for staff for your review of this project. So,
Absolutely.
Sam,
Sorry about that.
name's Sam Bohannon.
Moran, Mr. Moran, you heard the comments that I offered just a little bit ago concerning the issue of there not being an attorney representing the named applicant in this case. Let me just ask you if you would be willing to acknowledge for the record that you are appearing not in a representative capacity to advance the case or summarize evidence and to otherwise represent the applicant as an attorney would, but you're appearing as a fact witness only to clarify the facts relating to this case and to answer questions of the board. If you could acknowledge that, I think it'd probably get over this practice of law issue.
Yes, sir, I acknowledge that.
Thanks so much.
So thank you to Robert for going through the presentation earlier. Mine will be somewhat similar. I've got a vicinity map here. So in red is the Johnston Medical Center at Clayton, their total property. And Veterans Parkway, Highway 42 is running on the southeast of that property. And here's a project contacts, Sam Bohannon, that's me, the design engineer. Kyle McDermott, who is here tonight also, represents the hospital. And the owner's Johnston Memorial Hospital Authority. This is a same or similar site plan we saw previously. The red square is the existing 40 by 40 helipad that is currently on site. And the green is the proposed 50 by 50 foot helipad that is being proposed on the site and is across the driveway. And it's largely a similar type helipad. We are putting a similar type fence or perhaps even exactly the same kind of fence. It's 42 inches high, aluminum fence, similar to what is out there on the current one. And we're changing from the existing 40 by 40 helipad to a 50 by 50 after review with the users of the helipad, the pilots. And they requested the helipad to be slightly larger just for ease of use for them when they're landing. This is a few images of the very top one is an image of the existing helipad, and you can see the fence they currently have around the helipad in its existing location. And then the middle one, the middle photo is the proposed helipad location just across the drive from the existing helipad. You can in fact see the existing helipad over to the right-hand side of the photo and the driveway between where the proposed helipad are located. And then the bottom photo is looking slightly farther west or to the left of the middle picture, and that's an existing landscaped area, which also is a little bit farther away from the helipad is actually also a riparian buffer where there's a stream, so it's non-developable land between Johnston Hospital and the adjacent neighbors to the west. The findings of fact, we've written out a brief explanation of how we meet each of the findings of facts. I don't know that you necessarily want me to read through all of them, but I mean, I'll be happy to this time to answer whatever questions you have.
Raz, would we need him to go through each one of the findings of fact for the record, or is this sufficient?
Not necessarily so. I mean, the staff report, the application, the materials in your package are all evidence received in the hearing and by law. So I think there's probably evidence here in the written materials that could support the decision. So
Okay,
testimony is not necessary.
great.
If there were opposition speakers, it might be a different matter, but at this point, I think not.
All right. Okay, any questions of the applicant?
One curiosity question. Approximately how many helicopter trips in and out per year do you experience?
Yes, sir. And Kyle and I talked about this before, and he can correct me if I'm misstating, but in a year, it is approximately 30 helicopter trips on average.
Thank you.
Any other questions for the applicant? All right, thank you.
Thank you.
Appreciate it. All right, we'll ask if anyone would like to speak for or against. Seeing no one in our audience, I think we're safe to say no one is here, and we can close the public hearing, or the evidentiary hearing. So we will close the hearing, and we'll bring it back to the board for deliberation and discussion. Yep, everybody good? Hearing none, I'll assume we are ready to vote, and I will entertain a motion.
I'll move to approve the special use permit 2025-44-SUP, Stafford Johnston Medical Center.
All right, we have a motion to approve. Do I hear a second?
Second.
I have a motion and a second. Any further discussion? All right, all those in favor say aye.
Aye.
Opposed? Motion carries unanimously. All right. Thank you, board. Moving down to our next item of business, item number 5, new business. Approval of the Board of Adjustment.
Mr. Chairman, I'm sorry.
I'm
I
sorry.
keep forgetting to turn the mic on. If the board would care to, there has been a findings and conclusions that were prepared. They appear on page 57 through 60. If you would care to adopt the findings of conclusions and order now, typically in the past, it's been at the subsequent meeting after the order has been prepared by counsel or counsel for the applicant, but since you've got it before you, if you wanted to consolidate that action with the motion to approve, I think that would be acceptable.
Absolutely. And thank you for that. Yes, I have no objection to doing that tonight. It'll save us 30 days, so. What's the board's pleasure? Good? And just so everyone understands, typically we approve these formal findings at the next meeting, but if there's no opposition, I think they're already in before us tonight. They've already been prepared. If there's no objection by the board, I think we can approve those tonight. So with that, I'll entertain a motion to approve the findings.
So moved.
Have a motion to have a second.
Second.
A motion and a second. Any further discussion? All right. All those in favor say aye. Opposed? Motion carries. Findings are approved. Thank you for that. All right. Now back to item number 5, new business, approval of the Board of Adjustment meeting schedule for 2026. Turn it back over to staff.
Thank you, Chair. This is the meeting schedule for 2026. Pretty much the Wednesdays every month going throughout 2026. So this meeting, if looking for a motion and approval of the meeting dates, and then we can confirm that with our calendars here on staff.
All right. And I looked through them and I did not see any conflicts or any changes that needed to be made. So with that, entertain a motion to approve this 2026 Board of Adjustment meeting schedule.
Move to approve the Board of Adjustment meeting dates for 2026.
Okay, have a motion to have a second?
Second.
Motion and a second. Any discussion? Okay, all those in favor say aye. Aye. Opposed? Motion carries. Thank you very much. Are there any other items that are to come before the board before we adjourn?
No further items from staff, sir. Thank
All
you.
right, awesome. All right, with that, I entertain a motion to adjourn.
I'll move to adjourn.
Motion and a second?
Second.
Yeah, motion and a second. Discussion? All right, all those in favor say aye. Aye. Opposed? We are adjourned. Thank you.